here. Got this segment that we've been promising y'all for a really long time now, but we just now got it together because sometimes life happens and we don't get started as soon as we wanted to, but it's something a lot of people I think has been waiting for. So without further ado, let's get it on. Larry, how are you, my man?
Doing fine, thanks, Chris. How are you doing?
I'm doing excellent. Been looking forward to this. So tonight we're going to discuss, and first of all, let me just say to people who are listening, this is not going to be about is anybody guilty or innocent. That nothing like that. Not going to be taking sides. It's going to be strictly Larry's analysis from a legal standpoint of what the law says in the case, people being charged with, going into a case, what's a defense strategist, what's the prosecution strategist, what are they looking at as far as jury duty, basically what the lawyers are trying to do, what you're wanting the jurors to look at, maybe what's going through the juror's mind. Did the judge look at this law? Basically, it's just from Larry, from being a retired defense attorney, what he's looking at or what his analysis is as a lawyer. No, we're not our opinions on anybody guilty or innocent. Because now we're going to be looking at the murder of God, he's slipping my name now, Larry.
Ahmaud Arbery.
Ahmaud Arbery, who was murdered by and now they're slipping my mind. I just had it written down.
Trevor McMichael, George McMichael, and Brian. I forget his first name.
All right, so essentially, this young man walks into a house that's being built. One of the men or suspect him of being somebody who stole some stuff, and they get in the vehicle and start chasing him. Another guy joins in the chase and tries to block him in. One gets out, shotguns grabbed, and guns fired. Is that the essence of it, or can you explain it better?
Well, basically, in a case like this, basically, there's this house that's under construction, and the walls are not up, and Ahmaud Arbery and a bunch of other people would go in the place. Now, Ahmaud never stole anything, never took any property. He would, I don't know if you call it a shortcut or whatever, or just he's curious or wants to see what's going on. There were some mental issues alleged that he suffered. And actually, one of the rulings the judge made was that any mental issues would not be admissible in the trial.
Well, first question I have is, and somebody told me because something about the house wasn't complete. Was he even trespassing?
He did not own the property, so yes, he was trespassing.
Okay, so he was trespassing.
Yeah, I mean, as long as you're told not to be on the property, or as long as you're on property where you don't have an ownership interest or a leasehold interest or anything else, you could be considered trespassing. Though in
so
most
does that?
States, yeah, go
ahead, Larry. No, you go ahead and then I'll.
In most states, trespassing is not a crime. It's
that's what I was fixing to ask.
In Georgia, it might be a misdemeanor. In most states, crimes are designated either felonies or misdemeanors, and anything else is like a ticketing offense or something. You'd be considered a scofflaw, not a criminal. So if if you're charged with speeding, it's a crime. It's in the criminal, but unless you're doing reckless speed, you're just going to get a ticket and a fine. So
Okay,
that's
so
basically what trespass is, and it was in the civil law from Britain. It was called herbergage, Herberage. But I can't spell it. Basically, it was somebody who walked across somebody's grass without permission, and that was a civil crime, not necessarily a criminal crime.
so before I get to my next question, there would even be no legal grounds for a citizen's arrest for trespassing. Would that be a fair statement? I mean,
Based at least in Georgia and most states that I'm aware of, yes, there would be no grounds for civil arrest in a mere trespassing case. The
okay.
problem
So
is,
then these men suspect him for whatever reason of being somebody who stole some things, and they get in his vehicle and start chasing him. So what their grounds were going to be for they were going to make a citizen's arrest based on what grounds?
well, their claim was they were making a citizen's arrest on what they believed was a burglary, that he was in the property to take something. It turned out that he never took anything, so the ground in and of itself would fail. Basically, the civil arrest statute in Georgia that was in place at the time this happened was basically an old statute from slavery days. It was
Okay.
used to bring back runaway slaves, and it was also used to charge uh, Underground Railroad conductors or anyone who tried to free the slaves or entice the slaves to leave their masters. Basically, if you look back into the history, a slave was a valuable piece of property. And I know that this is not politically correct, but these were people who were treated as chattels, not as people. And
Yes.
in the South, in Georgia, and in the Carolinas, and in the deeper South, you had at the time before the Civil War, you had 4 million slaves, and those were the basis of the Confederate economy. So this is what these laws were there to enforce. They were much like fugitive slave laws, where if you found somebody taking a slave or helping a slave, that's what these civil arrest statutes were for. They
Okay,
just
so
and I think
at what
yeah. I'm
point
sorry. Go
when
ahead,
you have
Chris.
a try to make a citizen's arrest, do you stop? I mean, or are you waiting for the police to show up? I mean, is there a time that you stop? I mean, because obviously what I'm getting at is this young
Let
man
me.
is running down the street. You can see he's obviously stolen nothing. So what are you still chasing him for?
Well, let me read you the statute. It's a very short statute.
Okay.
This is from the 2010 Georgia Code. It's section 17-4-60, grounds for arrest. As I said, 2010. A private person may arrest an offender if the offense is committed in his presence, which obviously was not the case here, or within his immediate knowledge. That's that may have bearing. And then the second sentence, if the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. So the issue here is what qualifies. In the second section, the second sentence, it specifically says if the offense is a felony and the offender is escaping or attempting to escape. Well, it doesn't say it specifically defines the offense. A trespass is not a felony. A burglary would be a felony. A burglary is remaining on premises to commit a crime. So if you were standing in that house and you took and you took 2x4s, which there was a white couple who did that previously, but you're talking about an offense that is a felony, and the offender is escaping or attempting to escape. So both of those grounds have to be in the alleged crime. Now, if the man is escaping or attempting to escape a trespass, we're not talking about a felony. So that's one of the major issues. But the second part,
Okay.
the private person may arrest him upon reasonable and probable grounds of suspicion. When you see somebody running down the street or jogging down the street, as other people are saying, does that give you grounds of any suspicion? If you see a person cutting in and out of the house, does that give you grounds of suspicion?
They did see him go in the house, correct? Or did they not?
They claim they saw him coming out of the house, not going into the house.
Okay. All right. Okay. So they saw him coming out of the house, and
right. They claim he was running.
That. They thought. Okay.
The
I'm sorry. Go ahead. So they saw. All right. Finish. They saw him going out of the house. Go ahead and finish from there.
As I said, they see him going out of the house and they see him running down the street. Is that enough to make a citizen's arrest?
Based on that, you would have to suspect. So is that the way the law reads? They have to be suspected of he committed a burglary to make a citizen's arrest,
or any other type of felony. A person may arrest him upon reasonable and probable grounds of suspicion. Now the McMichaels themselves said they thought he was committing a burglary.
Okay.
And now, was that reasonable and probable grounds? So the answer is you have a two-part statement here. And the major part is the person has to be committing a felony and escaping or attempting to escape. So if the person is not committing a felony, my reading of the statute could be that it doesn't apply at all. Let's go back to the first sentence, though. A private person may arrest an offender if the offense is committed in his presence. Now, or within his immediate knowledge. Now, this is also problematic. Assuming that he saw the guy running out of the property, is an offense, and the first thing talks about an offense, not a felony. An offense can be a misdemeanor in Georgia. I don't think it could be a mere trespass, though, in either case. So the issue is define offense, define presence. Well, presence, obviously, you know what presence is, and this probably did not see the presence, but define what immediate knowledge is. That's the key. Those are the key words.
That is what I mean. I would guess I don't know what immediate knowledge is.
Well, let's go back to a little history. One of the McMichaels is a former cop. He's well involved still with the prosecutory system of the county and with the police force. And he's been notified because he lives in the area that people go into this property and may or may not be doing things. Now,
Right.
you're aware that there is a camera on that property. Because
Yes, I seen the camera where he actually walked in and was just kind of standing there.
right, but the thing is, he's not the only person on the camera, and the owner of the property at one point went to the police and asked the police to warn him to stay out of the property. And the owner said he never saw him touch anything or take anything, but he warned him that he's trespassing.
Arbery or somebody else?
Arbery.
Okay.
So the police, the cop allegedly told McMichael that Arbery has been warned to stay off the property to stop trespassing. But the key word,
so he has been warned to stay off the
trespassing.
Okay.
The policeman has never told McMichael that Arbery has taken anything. So
and there's no reason to believe that he is. I mean, and there's no reason to believe he is the one, because there could be numerous people that could have taken that.
Correct, and from what I gather, there are pictures of this white couple that the owner has seen actually taking 2x4s or building materials. But Arbery,
and I know that the owner said that he thought that some of his employees had actually stolen some of the stuff.
That too, but
okay.
But
so
he is specific. The owner specifically said that on the camera he never saw Arbery take anything. He just saw Arbery on the property, which does not belong to him. Hence, he's trespassing. Period.
Okay.
I don't know.
So
I don't know if there's any racial incitement here. I don't know if Arbery was a white guy, if he would have asked the police to tell him to stay off the property. None of that has ever come out. But obviously, we're dealing with the South, so it's possible.
I mean, let's be honest. I mean, this is a rural town in the South. Yeah, I mean, I'm not going to say race didn't play an issue in that. I think, if we're going to be totally honest, So now, when he leaves the house, did he immediately start off running, or did he start off walking, or?
I don't remember. I tried.
Okay, that's neither here nor there. So the McMichaels, what do they do? Do they call the police, or do they immediately grab a shotgun, get in the truck, and go after him?
From what I gather, they just get their shotguns in the truck and go after him. They see him running, and he said,
in this day of cell phones,
pardon?
In this day of cell phones and home phones, they don't contact the police. They just start chasing this young man.
That's the way the prosecution set up the crime scene. That they just were chasing the young man without doing anything or without saying anything. They attempted, at one point,
Now there was some conversation between, according to on the stand, he said that they're, telling him to stop or whatever. But
that's correct.
Anyway.
Because a citizen's arrest, what's supposed to happen in a citizen's arrest, and though it does not say so on the statute that I just read, is they are to detain the person and contact the proper authorities and turn the person over to the proper authorities, which which at this point I have no idea if you can get an intent to merely detain from what was happening here. But again, that doesn't mean anything in this crime. In the crime.
Okay, they can obviously see. I mean, you could obviously be able to tell. Anybody could that the young man had shorts and a t-shirt. So obviously he had not stolen a 2x4 or some kind of power tool. So what is your probable cause now?
Well, The issue is he could have stolen something that could have fit in his pocket. I mean, you know, there are he could have stolen a level, or he could have stolen a hammer, or he could have stolen a packet of nails. I mean, it all
okay, if he stole a pack of nails, would that still constitute a felony?
The answer is I'd have to read the Georgia Criminal Code to find out the value of a crime to do it's a penalty. The penalty could be a felony. The answer is maybe. I mean, if somebody is building,
is that something a court? Is that something a judge would have to rule on? Let's just say that he got they successfully arrested him and say he had a pack of nails. Is that something the court would have to rule on, or is that in Georgia law that we just have to look up?
Well, ultimately, a crime has to be proven by the prosecution within a reasonable doubt. So if the if they are charging Mr. Arbery with a crime, and he stole something worth more than the threshold of a felony, and it's something that he could put in his pocket, the prosecution would have to prove that if they were charging Arbery with a crime. So the answer is yes. And you also, when you put somebody before a grand jury, and Georgia is a grand jury state, you have to prove to the grand jurors that there is probable cause that a certain crime has been committed. So if Arbery had lived and they were charging him with a burglary, and he had a piece of imported Italian marble that he was running under his shirt, and that imported piece of marble was worth $500, you would probably have a felony. If he had a packet of nails in his pocket and those nails were worth $5 or $10, then you don't have a felony. So it all depends what's taken. And it all depends what justification is claimed. Now, if Arbery was on the property and one of the workmen who you had mentioned that the owner of the property thought were stealing stuff, and this workman gave Arbery something worth $250, Arbery might be in effect receiving stolen property, but he's not involved in the theft at this point. And he has to have knowledge or an idea, or at least that that this property is not from this guy to be able to give to him. So when you're talking about criminal conduct, it's not like conduct you see on TV all the time. It's not right in your face criminal conduct in most cases. It has to have an interpretation, and it has to be, and all of the elements of the crime have to be proven within a reasonable doubt in order to convict someone. So here, it's a little bit different, because in order for the McMichaels and Bryant to prevail on their claim of justification, and I'll talk about justification a little later, they have to be able to show that, one, it's a felony, or we'll do step 2 first. One, it's a felony, and that he's escaping from committing this felony, and 2, that they have a reasonable and probable grounds to suspect him of doing this felony. And now to go back to 1, they have to, 1 is even more difficult. The offense
Larry, can you hear me?
Yeah. I can
All right,
hear
back
you.
up just a couple of minutes because I had three phone calls coming in. I had to decline it. I think you said something.
Okay. Where did I leave off?
Tell this person I'm on the phone. Remember
No,
one
no,
second.
what do you want me to repeat?
Just hold on one second though, and let me text this person, tell them I'm on a Skype call, and I'll call them back.
Okay, no problem.
Oh, this is aggravating. So what we're going to do is we're just going to go back, and if the text message don't come on, and because if not, it's just going to um, keep coming through. This and maybe he won't. Let's just. I think they won't. Hopefully they won't call again. But what we're going to start is one second. I hate this thing. I got to switch accounts to be able to send a
All
damn
right,
text
I'm not
message.
going anywhere.
Well, I called and I declined it, and then he called again. I declined it, and I called again. I said, "Can I call you back later?" And he called a fourth time. He hadn't called back, so maybe he's not going to. But it's taking forever to switch accounts on this thing. But anyway, all right. So let's just go with this because you can hear me, right?
I can hear you. Yep. I
All right,
can't see, but I can hear you.
yeah, don't worry. I'll be back in a minute. So Aubrey may have taken stolen goods. Now, take me from what you said from there. You know, if it received stolen goods.
Okay. Well, oh yeah, that was if somebody, if the owner, as you said at the beginning, the owner had suspicion that some of his workers were stealing from him. So if Aubrey was on the property and Aubrey had received something from one of those workers, um, the charge, unless he's doing something with the property and he's in, the old word is in cahoots with or conspiring with these to commit a crime, then you might have a felony there too. However, if
Okay.
the guy just gives him something and the guy says, "Oh, this is mine and it's not necessary on the job, so here, you take it, maybe you can use it," he very well may have received stolen goods, but he's probably not an aider or abettor or conspirator. And he probably
All right.
did not have knowledge. So
So
in that scenario, it's not a burglary or not a felony.
okay. So take us through this now. So they jump in the car, or truck, grab their shotgun. I think maybe one grabbed a pistol. I don't remember. And they start chasing him. Correct?
Yes,
For 5 minutes.
they try to cut him off.
Uh-huh.
Um, they try to cut him off. Their claim is they told him, "Stop, we want to talk to you," or "Stop, we want to talk to you about what you've been doing in that house," or something to that effect. The
So
obviously Mr. Arbery is not here to testify, so
uh-huh.
but
That
according
basically
to,
sounds like what I remember the testimony he said on the stand was he said something like, "Hey, stop, we want to talk to you." But
right,
so
exactly.
let me
But
just interrupt this here too.
we don't know if
Uh,
that's what he actually said. That's what he testified to saying.
well,
And don't
let's
forget,
just say for the sake of argument that he did say, "Hey, stop," or "Hey, stop, we want to talk to you." So here you've got a young black male that's being chased by two white males saying, "Hey, we want to stop to you." Now, don't you think fear is going to be running through this young man at this point? I mean, I know if anybody was chasing me saying that, white
well,
or
well,
black, I
well,
would be
well,
scared, especially a
well,
black male in South Georgia.
well, the interesting thing is, and this is one of the major problems with the defense's case. He did not say, stop, we want to make a citizen's arrest.
Mm-hmm.
If he did that, then there might have been a justification for what ultimately happened. But just saying, but chasing a guy with guns when you're obviously not law enforcement, you're not driving a police cruiser, you're not in uniform. I don't know if McMichael had his old badge or whatever, and he used it. If he flashed the badge, they never said
that would be illegal, though.
Pardon?
That would, that would be, he would be impersonating a police officer then, because I asked the police officer that, and he said, once you retire, that badge is no good.
Absolutely, but the issue is we're looking at what Arbery may have felt and what Arbery may have heard. I mean,
if he had said, "Stop, we're making a citizen's arrest," then there could have been a defense based off that, as opposed to saying, "Hey, stop, we're going to talk to you."
You still have to prove the rest of the terms, but
right.
In that scenario, Arbery may have been informed of what these guys were trying to do.
Okay.
The issue here is really, did they consider the citizen's arrest at the time, or did they consider it after the fact when they were preparing for trial? And the answer is, we don't know that. And that's attorney-client privilege, and we'll never know that unless one of the McMichaels or Brian says something. Hopefully, I shouldn't say hopefully. Hopefully, their attorneys inform them to keep their mouth shut, and and things like this wouldn't happen. Now, I'm just taking that from my years as a defense attorney. I don't want my clients to ever say anything to the police. Period. But
and I've listened. I don't know if you listened to I've listened to some when they started talking to the police that day. At what point did the other man get involved in this?
He was following almost from the beginning. And he was the one who actually took the cell phone photographs of the stop and what was happening.
Because see, at first, when I found that, I didn't know how much he was involved in, I was actually a little sympathetic, saying, "Wow, he got 30 years for taking that video." I did not realize that he was actually involved in the case, trying to cut him off with his vehicle.
And he tried to cut him off. So he was involved. Was he involved in the felony murder? Well, he was convicted of it. That was probably a weaker case, and it was probably based upon the fact that the three of them were tried together. I would, if
you're involved in something like that, aren't you just as guilty as the person that pulled the trigger?
Only if you're involved with the same degree of culpability. Let's do it here. It all depends what your state of mind is, what was going through you. I know we've discussed this before, but if I am a intellectually retarded, and I don't want to use that term, but I have the I'm a 20-year-old, but I have the mental capacity of a 4-year-old or a 7-year-old. If somebody comes up to me, puts a gun in my hand, and tells me to shoot that guy, he's raping your mother. Okay? Nothing else. And I understand what rape is as a 7-year-old. I shoot the guy. I don't have the mental capacity to be charged with murder. I probably don't have the mental capacity to be charged with anything. The guy who gave me the gun and told me to shoot the guy can be charged with murder, felony murder, and everything else. And I am totally, I'm incompetent to commit this crime. I mean, they may put me in a mental institution or something like that, but I'm incompetent to be charged with murder for this crime. And it could be the same.
How did they actually, I guess, get him boxed in? Or did he just get tired and stop running?
The only thing I did was try to prevent this guy from getting away from these two other guys, and knowing nothing else, I might be lesser culpable than the other two. And in fact, the sentences that were given, the McMichaels have no chance of parole at all, but Brian can get out in 30 years. So
okay.
he was held to a less culpable standard.
So so he stops, and he's taking his stuff on, and I can't. It's been a while since I watched it. So this other guy gets out of the vehicle and comes at him with a shotgun, and he's obviously unarmed, and he comes at him with a shotgun, and Arbery reaches for it, and that's when he shoots him. Or is that how it happened, or was there something? Did I leave something out?
No, that's what happened. That's obviously the claim that if you read the evidence and allegedly if you see the photograph, the car is blocking that, so you don't see what's actually going on. I don't believe you actually see Arbery reach for the shotgun or at least grab for the shotgun. Now, don't forget, Arbery.
So we don't know. He could have just got up out there and just gunned him down for all we know.
Right. Now, Arbery was shot 3 times. And the
3 times?
The coroner's inquest say that either the first or the third shot was fatal.
I was not aware that he was shot 3 times.
Well, when I was reviewing the court testimony and the testimony online, it was said that he was actually shot 3 times.
With a pump shotgun. Wow. Huh.
And at short range distance, I mean, you're touching the gun. Now, the interesting thing here is there was a claim of self-defense. Self-defense.
Okay.
Is
well, first off, before we get that, tell me what all 3 men were charged with. What were their charges?
They were all charged with felony murder and murder with malice, and they were all charged with.
Charges, right?
They were all charged with kidnapping, unlawful restraint, and there was one other charge that I'm just drawing a blank on. There were, if I'm not mistaken, there were 5 charges.
All right, so the one was obviously self-defense, and the other pleas of not guilty, what was it based on?
Again, they were trying to use they were all trying to use self-defense, and they were all trying to use the citizen's arrest.
Okay. All right. So, now you say something about self-defense, and I cut you off, and I'm sorry if you don't remember. I mean, I'm sure we'll get back into you.
Self-defense is a justification. We all know that Arbery was killed. We all know it was a homicide. Now, what we're trying to now what the defendants are trying to show is they were justified in killing Arbery. Now, Georgia is one of a number of states that has the man is the king of his castle legislation. So you can kill someone who's attacking you, who's attacking someone else, who's breaking into your property. You have the right under Georgia law to kill that person.
Mhm.
You don't under Connecticut law, but that's beside the point, or New York law. But in Georgia law, you do not have to retreat. Even if you can retreat to get out of the way, you do not have to. If you believe that force is intended against you, you can use equal force to oppose that force. If you believe that force is being used against your wife, you can use equal force to protect her. If you believe that this guy is going to use deadly force against you or your wife, or you then are perfectly legitimized to use deadly force against this person. That's the man in his castle law. That is not self-defense. Only that is an invasion. Self-defense is a justification. And I've also copied the law of self-defense, and I'm going to read the most important parts. We're again talking about the 2010 Georgia Code, Title 16, Statute 16-3-21. Use of force in defense of self or others. Evidence of belief that force was necessary in murder or manslaughter prosecutions.
Okay.
It starts out, use of force in defense of self or others, evidence of belief that force was necessary in murder or manslaughter prosecutions. That's the title of this section. A person is justified in threatening or using force against another when and to the extent that he or she reasonably believes that such a threat or force is necessary to defend himself or herself or a third person against such others' imminent use of unlawful force. However, except for as provided in Code Section 16-323, which doesn't come into play in this matter, a person is justified in using force which is intended or likely to cause death or great bodily harm only if he or she reasonably believes that such force is necessary to prevent death or great bodily harm to himself or herself or a third person, or to prevent the commission of a forcible felony. Now, a forcible felony can be breaking and entering your home or your car. The interesting part of this is, and this is part of what we'll have to get to later on, did the fact that this guy tried to take the gun away, can somebody reasonably believe that it was necessary to shoot him 3 times? And the answer is that's one of the things that the defense has to prove. Now, I'm going to do an aside before I read the next very important thing. In Georgia, you have at some time before trial, you have to inform the court that you are going to use the justification of self-defense as a justification or a defense in your trial. And the judge would then have a hearing on it. And the judge can determine whether he believes you can use it or he believes you can't use it. Now, if he believes you can use it, it's in Georgia, it's not up to you to have to prove the self-defense. It's up to the prosecution to disprove the self-defense, but with the standard of beyond a reasonable doubt.
Okay, so the burden then
The burden changes.
so the defense does not the defense does not have to prove they use self-defense. Prosecution has to prove that you didn't.
Correct. If you can make a good faith claim that you acted in self-defense, the prosecution then has to prove beyond a reasonable doubt that you did not act in self-defense. So let me continue.
Okay.
Section B is the most important part of this for his claim of self-defense. A person is not justified in using force under the circumstances specified in subsection A of this code, which I had just read, if he, A, initially provokes the use of force against himself with the intent to use such force as an excuse to inflict bodily harm upon the assailant. 2, is attempting to committing, or fleeing after the commission or attempted commission of a felony. Or 3, was the aggressor or was engaged in a combat by agreement unless he withdraws from the encounter and effectively communicates to such other person as attempts to do so. So, the major problem with this whole claim is if McMichael initially provokes the use of force against himself, he's not entitled to claim self-defense.
And when you get close enough to somebody with a shotgun pointing at them, I mean that's pretty close. I mean,
if I'm trying to force him to stop between two vehicles, that's pretty close.
okay, so it takes a while, but these men are charged now. Obviously, with the makeup of this county, you're going to have a predominantly white jury. I believe it was 11 whites and 1 black person on the jury, I believe. So,
and there were major issues about that because the defense used all of all of their peremptory challenges against person for no reason or no stated reason to exclude 11 potential black jurors.
do you have to give a reason?
No, you do not. If you're claiming that the person is biased for some reason, let's say a black man is one of the prospective jurors and he's a good friend of Mr. Arbery. As a defense attorney on that scenario, I would object, saying that he could be perceived as a biased juror for the prosecution. And if the judge would agree to that, then the judge would dismiss that juror, and it would not count against my peremptory challenges. If the judge does not think that he's a prejudice because he's a good friend, then I would be forced to use one of my peremptory challenges. A peremptory challenge is used to knock someone off a jury who you don't believe will be sympathetic for your client, but you have no ground to believe that he has any animosity or bias against your client.
Okay. So obviously going in this jury, I mean, usually there's a science, but obviously the prosecution's hoping to get more than 1 black, and I'm guessing they would probably hope to get some females because usually some black females are more, I
Correct.
guess, let's just say that females are going to be more emotional than what men are.
Now there were 20. The black citizen population of this county, according to the internet, is 27% black minority.
See, I didn't realize it was that high. So I mean, and out of 12, you didn't even get nowhere near a.
No, you got one black person, and you probably got him only because the defense attorneys ran out of peremptory challenges. Now, the interesting thing is, and this is something I don't know in Georgia, is how many challenges each attorney gets or if they're all lumped together.
Does it matter? Doesn't it vary by
Yeah.
state or vary by case and jury
Well,
selection?
it
Because
matters.
I've heard of
It matters by
calling
state,
300 people, for
right? But if each one of the defendants gets 10 peremptory challenges and the prosecutor only gets 10, then you're talking about 10 to 30.
okay. I mean, let's just say, what do you go in there and you'd have you had 40 people, and what would each of them get? 14 strikes each.
I'm sorry, I didn't catch that.
So say say you narrowed your jury pool down. So, okay, we're picking. I mean, is there a certain number they get to a jury pool down? Is that up to the judge? Is that up to the particular case? I mean, could there be 60, a jury pool of 60, and each one gets what? 24 or 29 strikes?
Well, that's the whole thing. I don't think they get that many strikes. I think that I think
I'm just asking, is there a certain number the jury pool actually gets whittled down to every time? Like, is it going to be whittled down to 30, and each one of them gets 9 strikes, or does it just depend?
That all depends on the state you're in.
Okay, all right.
The issue
I mean,
the issue is you select a jury pool. A pool is selected. There could be as many as 300 people there in waiting for various trials, and they sit before the judge, and the attorneys voir dire them, and the attorneys can then object on cause, or then use a peripheral challenge. If the jury pool gets reduced to beyond a sufficient number, some states allow you to just add more prospective jurors to that pool, or some states require you to get a whole different pool.
Okay. All right. So, Larry, you are the defense attorneys.
Yes.
And you're looking at this jury. Do you know how many white men was on it, or
Pardon?
as opposed to white women?
I believe it was 6 white men, and I'm sorry, I believe it was 7-3. But hang on, let me see. Might be able to get that fairly quickly.
Wow.
Okay, there were 12 white women and 3 white men, because they did a 16-person pool, 12 jurors and 4 alternates. 1 black.
Okay.
So obviously the jury was predominantly white women.
All right, you said it was 12 white women, 3 white males, and a black male?
Correct.
Okay.
Wait a second. Was it black male or black female? Hang on.
So it doesn't tell you who. It doesn't tell you the exact name of the jury. Just says you who.
I'm sorry. It only says a black person. Doesn't say male or female.
So it doesn't tell you who the alternate was. It just tells you what the whole thing.
Correct.
Okay. All right. That's neither here nor there. Because it's still a predominantly white jury, and let's just say they, you're a defense attorney there. Obviously, I believe that nobody's going to think they're going to be able to get an outright acquittal. But how are you feeling about at least getting a hung jury? I mean, you think you feeling good about this?
Well, I'm feeling fairly decent about this. In order to get a hung jury, I need to get one of the jurors who goes against the bunch, goes against the majority, and is strong enough to sit there. Now,
so you just need one.
What I have to worry about is that juror not following instructions, not getting sick or anything else, so they would replace him with another juror.
Okay.
But yeah, if I'm there, if I'm pretty sure I'm not going to get an acquittal, then yeah, the best thing I can do is a hung jury or a mistrial, one or the
Well,
other.
I mean, I would. I don't think. I think it'd been possible to get. I think your best hope would be somebody's best hope would be a hung jury.
In that case, yes.
I mean, so
But
now
don't
since
forget,
you've handled both,
my purpose in
so
this is not to get someone who's innocent or guilty. My purpose is to explain the law. So that's
right,
why
right,
we're talking about the difference between an acquittal and a hung jury.
right.
Yeah, you
Now
have to
let's go to the other
realize
side.
you have to
If you're the
realize.
prosecution,
Pardon?
I'm sorry. And I was going to say, so if you're the prosecution and you see that jury, are you nervous?
Yeah, I am, and I'm nervous for more than one reason. Um, we didn't go into this, but if you look at the whole pretrial procedure, the prosecutor who is prosecuting this state is from a neighboring county. Every single
Mm-hmm.
prosecutor in the county where the crime is committed recused themselves because they knew McMichael, or they knew the prosecutor who talked to McMichael, or they knew that McMichael was a former cop. So we have a prosecutor from a totally different county prosecuting the state using witnesses from the county where the crime was committed. So yeah, I'm
So
very
you,
concerned about getting a conviction, because I have to
so you're
convince
concerned not only
12
because of the jury
people.
makeup, but because you're an outsider coming in to the county.
Right. One of the reasons
Okay.
I have to convince 12 persons who don't know who I am, believe that I'm a hired gun from the state coming from another county to go against three young men, or actually three men, who are solid citizens in this area, and I'm trying to convict them of murder. And I have to have 12 sitting jurors agree that I've proven my case beyond a reasonable doubt.
Mm. So that I bet there was anxiety there. Okay, so um, you're going into this thing. You know, and I'm just I'm guessing the medical examiner testified for the state. Any other witnesses of notoriety the state called?
Uh, we called I believe the owner of the house was called, telling
Mm-hmm.
him, what was going on. I believe that the police who came in, after the fact, after they were called by also one of the defendants, after the fact, came in and saw the body. They testified. There was
Did they move the
testimony.
body?
Pardon?
Did they move the body? I thought did they move the body somewhere like under a tree that had a battle flag? Somebody told me that. I never looked it up.
Um, that does not ring any bell to me. So the answer is I
Okay.
don't know. It could have
Yeah, I
been
could
they
have that
could have
totally
moved them out of
confused.
the road. It could have been they moved them out of the road. But um, there was there was no question is that they shot and killed this guy.
Right.
They're not saying, "Oh, I didn't do it." No, it was an accident or anything like that. They're saying I did
Mhm.
it, but I was justified in doing it. And if and I don't know when they concocted the self-defense aspect, or the citizen's arrest aspect, because the alleged first two policemen on the scene were told by the prosecutor not to arrest, and one of those policemen testified that he believed there was sufficient cause to make an arrest. There was a number of, for a better word, shenanigans going on to keep these guys out of jail. The police
Yes,
did not.
I believe one of the female, was it one of the police officers or one of the prosecutors? Wasn't she involved with one of them or something?
Yeah, that was the very first prosecutor. And when the
I mean, 'cause how long did this thing go on? They went over like a year or something before these men were arrested, correct?
no, it was only 2 or 3 months. But the fact is, they weren't arrested until an attorney that Brian interviewed for some reason but didn't retain, submitted his tape of what was going on to a radio station. And that's and until that happened, they may not have ever gotten arrested. And why this person did it is not, and after that, everything fell into place. People lost their jobs in the prosecutorial office. People recused themselves. The second prosecutor picked, did some preliminary work on the case and then recused himself. Every prosecutor in the county recused themselves. They had to, as I said, they had to drag in prosecutors from every town, from the next county or from Atlanta. And there was a lot of the evidence and the review of the evidence was being challenged. So the FBI agreed to come in, and the Georgia State Bureau of Investigations agreed to come in. And only after the Georgia Bureau of Investigations came in were they actually arrested.
So other than owner of the home and the state's medical examiner, do we know of anybody else testified for the prosecution?
Yeah, hang on. I'll hang on one sec. I have the list.
Okay, yeah, I'd like to hear who all testified for the prosecution.
Okay, a police officer testified. He spoke to the owner of the under construction property. He said that he was looking for Arbery to warn him against trespassing. Having known Gregory McNichol professionally, in December, they discussed the unidentified black male with Greg. So allegedly they didn't identify him, but later on he did identify him. In fact, he expected Gregory to be an expert witness on the phone with 911 to identify him. But he never, this guy's name is Robert Rash, and he never deputized Gregory or gave him any authority. And Rash was the one, Rash shared security camera videos of Arbery with the McMichaels 12 days before the murder. Can you hear me, by the way?
Yeah, I'm listening.
Okay. Another police officer testified he was seconds away from the scene at the time, and he responded to a non-emergency report about a suspicious black male leaving a house under construction. Listen to the wording when we talked about citizen's arrest. He's testifying to a suspicious black male leaving a home under construction and nothing else. And he said that Arbery may have been alive when he got there, but he heard a death rattle and didn't do anything because he didn't know what to do. He testified that he questioned Brian, who was the third subject, that Brian claimed he was not familiar with Arbery or the McMichaels when he joined the case. So why did he join the chase is an interesting statement. Brian never testified.
He did not take the stand?
No, Brian, only one of the McMichaels took the stand. I think only.
I thought he took the stand. Oh, he must have told the police that he originally got. He told them he was trying to help them, I believe.
Right, but he also said, this is what the policeman is saying, that Brian, the defendant, said, that he was not sure that Arbery did anything wrong, so that he did not know if he should have chased Arbery at all, that he tried to corner Arbery with his vehicle 5 times, that Arbery had to stop his catch his breath and was tired of running, and then he heard one of the Michaels shouting at Arbery, "What did you steal? What did you steal?" So, I mean,
Wow.
the policeman has just killed any claim of either self-defense or citizen's arrest by testifying to what Arbery said. Now, you're all aware of your presumption of innocence and the fact that you do not have to take the stand and you do not have to testify against yourself. But if you are questioned and you answer a question and you turn out to be a defendant, anything you say to a policeman or anything else can be used against you unless you should have been Mirandaized and you weren't. So here you have a policeman questioning Brian without giving him any of his rights, and then at trial testifying to what Brian said. And, obviously at some point in pretrial, the judge conducted a hearing, or a judge conducted a hearing of whether Brian's testimony to the policeman was admissible, and the judge found that it was admissible.
Yeah, that's what I was going to ask next about about his admissibility, that statement. So obviously the judge found it was admissible.
The judge found it was admissible, and the police officer was allowed to testify. Now, don't forget, if your statements to the police officer is not admissible, but you said something on the radio, or if you said something to a newspaper, if you said something to your best friend, and that person can testify against you because that you have no privilege. If you said something to your priest or rabbi or your attorney, then they cannot testify against you because there's a privilege. Your wife cannot testify against you because there's a privilege. And the lawyer, your wife, and the minister cannot breach that privilege. Only you can allow them to testify against you. And obviously you're not going to. So let me get back.
So the prosecution would just read that guy's statement. He said, just for the police, what he heard and heard the gunshots.
Well, no, the guy didn't do a statement. The guy was there and said that he questioned them, and these were the answers to the questions.
Right, but would the prosecution read that to the court?
No, the prosecution would have the policeman testify directly.
Oh, okay, I got you. The policeman testified. He testified what he said. I got you. Okay, I understand.
Yeah, he testified what Brian said.
Now let's switch to. Was there anything else on the prosecution side you wanted to add?
Yeah, there were a number of other witnesses called. Let me get back to the.
Okay. I'm sorry. Go ahead.
Computer. Okay, another police officer named Duggan also came on the scene, and the jury was shown his body camera and dashboard camera footage, which included graphic video of Arbery's body. Duggan said he was intending to stop the bleeding from the chest wound, but then he realized that Arbery was already dead.
Okay.
He said that Travis McMichael was covered in blood, and asked if Travis was okay. And Travis replied, "No, I'm not okay. I just effing shot somebody." Travis, Duggan described Travis as very upset and cooperative.
Didn't his father make some kind of statement about you had no choice?
Well, that's what I'm getting to. The next policeman, and another policeman testified that he knew Gregory McMichael, who was pretty amped up and seemed a little upset. And then he said that Gregory told him the following: he saw Arbery hauling ass down the street past his house in a dead run. That Arbery had been breaking in all these houses out here. He makes frequent trips to the neighborhood and gets caught on video cameras every third or fourth night, breaking into places, and no one's been able to catch him. That a driving force in my mind is my son had a missing pistol and a guy I don't know. For a fact, this guy has been going over doing this crap over and over. So he's trying to set up that he has a dangerous neighborhood, and this guy is the chief cause of everything that's been happening.
So
he said, "I saw him. If I could have gotten a shot, I would have shot him myself."
he said that.
Gregory McMichael.
He made that statement.
Yeah, he said, if I saw him. If I could have gotten a shot, I would have shot him myself. And he said that the blood on Gregory's hand came from checking if Arbery had a gun, and that Arbery was an asshole. He was hooked up when he came around the corner. So already they're starting to attempt to make a claim for either citizens or a claim for citizens arrest. Now another policeman who also knew Gregory, interviewed him at the police station later. Gregory told him, "I don't know. He might have," in response to the question of whether Arbery broke into a house that day. So at least at this point, they have McMichael saying he didn't know if Arbery broke into that house or not. So this puts another nail into the coffin of citizens' arrest. He said that he only saw Arbery hauling ass past his house, getting the hell out of there, prompting him to take out his handgun and call for Travis. That they chased Arbery around the neighborhood for a bit, but he wasn't winded at all. That Arbery was trapped like a rat in the chase, wanting to flee, but realizing he was not going to get away. That Arbery, and here he is, that Arbery wanted to grab Travis's gun and probably shoot Travis. If he had gotten that shotgun and there was no separation between Travis and him, I was going to cap his ass. So you got major problems already for a claim for citizens arrest, and you have three guys already contradicting themselves in the police testimony. You have another guy who interviewed Brian, who's the third guy at the police station later on. He says Brian told him that he had seen Arbery running down a road with a truck following. So Brian entered his own vehicle to assist. That he had not seen Arbery before and did not know if Arbery was involved with any past incidences. That during the chase, he tried to cut off Arbery multiple times, angled Arbery off the side of the road but didn't hit him, and that Arbery was trying to open Brian's truck door during the chase. The officer further testified that he found Arbery's prints on Arbery's truck door next to the dent in the truck's body.
Wow. Huh.
Then you have the first Georgia Bureau of Investigation agent. He interviewed Brian in May. Brian said he didn't know for sure if Arbery did something wrong, and here's where you got an interesting thing, but instinct indicated Arbery did, and Brian ultimately figured he stole something. And these are in quotes. Another nail in the coffin. Compared to his earlier interviews, Brian played down his involvement in the chase in the later interview, stating that he wanted to slow Arbery down and take a picture of Arbery to identify him to the police. So now he's trying to say that he was not, that he had an ulterior motive for joining the chase. Then we have another Georgia Bureau of Investigation agent, and this guy was the lead agent. He testified that Brian's behavior was not that of a witness, as he was pursuing Arbery and trying to box him in between two different vehicles. So basically, he's saying that Brian was involved in the crime. During the chase, Brian had to reverse his vehicle to continue his pursuit of Arbery after Arbery turned into another street and Brian overshot the turn. Maps compiled by the Georgia Bureau of Investigation showed that the Michaels vehicle looped around to the other end of the street Arbery was on, such that Arbery was between Brian and the McMichaels with no way to leave the street without meeting one of their vehicles. So basically, the McMichaels and Brian are now trapping Arbery. Then they have, pardon?
Kidnapping.
Basically, that's your kidnapping or unlawful restraint. Then you have one other. Bureau of Investigation who analyzed the phone records and concluded that Brian did not communicate with the McMichaels on the day of the shooting or before.
Now, let me ask this. So far, now there's only been one phone call to the police about a trespassing.
Correct.
Okay. Sorry, I didn't mean to interrupt you.
And that's not even a good call. You see, what the prosecution did here is they're leaning on the police officers and they're leaning on the authoritative air of a police officer, and they're leaning on people who actually knew Gregory McMichaels to disprove his claims based on his own words during the investigation. Now, at this point, neither of the McMichaels nor Brian had been arrested. The police, in my mind, are assuming either a self-defense or a justifiable claim of citizen's arrest, and they are doing everything in their power to avoid making the arrest. But they're listening to this testimony, and they're testifying on the stand against the McMichaels and Brian, and they're basically ripping to shreds any justification they might have.
Okay, so let me ask you this. I know that I know your opinion on witnesses on the stand. Or you're the defense attorney. Are you putting the boy on the stand that shot him?
Am I putting the boy on the stand that shot him? This is
are you putting anybody on the stand? Are you gonna call any of the are you putting any of them on the stand?
You're asking me as a prosecutor or as a defense attorney?
No, I'm asking you. I know as a prosecutor, if you're, so let's go into the defense now. You're the defense. Are you calling any of them to the stand?
Absolutely not. No.
Not even when he pulled the trigger?
Well, we know who pulled the trigger. The one who
Right.
pulled the trigger is the son.
Mm-hmm.
Right.
So you're not even putting him on the stand?
The only way that I would allow one of my people to testify on this is if the prosecution would make a deal with me for a lesser offense. This is a case where I would, I would have.
Let me put it another way. And again, let's just be real. There's racial elements out there. I mean, are you not think when by them putting him on the stand, their strategy was try to portray him as, hey, this is one of y'all. This is a good old boy. He was looking after your stuff. He's trying to protect us from this criminal element that's moving in. Much like the white flight, stuff like that. Are you not trying to portray this in that way, trying to humanize him with the other white jurors?
The answer is maybe. The defense attorneys had one of them testify. That was the one who actually did the shooting. The father, who was the police officer, did not testify. Brian, the third man, did not testify.
Right.
I don't know. Yeah, that's definitely a thing to do, especially.
That's the thing I can get through my mind, because we see so much now. And again, I'm not getting into whether it is a terrorist group or a group that is peacefully active, but we hear so many things about Black Lives Matter. That's what I'm saying. I'm just being honest, because we know that race plays element in everything. And I'm not, again, we're on this show, we're not choosing sides. But I mean, when you're in a rural Georgia town, you've got an all white jury, or you're not trying to humanize him, have the white jurors relate to him as, hey, we're trying to, stop, this. The next thing is going to be, stealing and this, and he was just protecting your stuff. This is your neighbor. This is the guy you go to church with. I mean, is that what a defense attorney is trying to do?
That's what a defense attorney is trying to do. But okay, the defense attorney may not be allowed to do that, because what you realize when you're in court, when most people think of a trial, they think of only the actual testimony that's allowed into court and the objections and whether they're sustained or not. There is a whole procedure leading up to the trial where the judge will rule on the admissibility of certain evidence. Now, in this case, the judge made 5 rulings prior to trial on the admissibility of evidence. And what I'd like to do is I'd like to read you those 5 rulings, and I'd
Please,
also
by all means, go ahead.
Pardon?
Please, by all means.
Okay, and then after that, I'd like to read you McMichael's testimony, because it's important, because it brings about a lot of the same questions you asked me. But hang on one second again. Actually, 6 rulings. And the first one is the judge denied a prosecution motion to bar testimony that the neighborhood was on edge at the time of the murder. So the judge is allowing that testimony in, and that can be used by the defense to show that there was problems with the neighborhood, or at least alleged problems with the neighborhood. The judge is allowing that in. The the judge ruled that the defense could not introduce evidence of Arbery's prior bad acts, noting that the McMichaels were unaware of Arbery's past at the time of the murder. He justified this ruling by stating that the character of the victim is neither relevant nor admissible in a murder trial, which is probably grounds for an appeal, or at least a possible appeal, and that such evidence might also mislead the jury into thinking that Arbery's murder was somehow justified on potential future dangerousness, which is a very interesting ruling. It's one that surprised me when I was reading it, because I had never seen that ruling before in 40 years as an attorney. Basically, what it's saying is they feared that because this guy may have done something bad in the past, that he could continue to do something in the future, and they didn't want sympathy aroused for the defendants because they took out a guy who had the potential and no major criminal record to do anything like this. The next one is, he ruled that the defense could not introduce Arbery's mental health records in evidence, citing medical privacy and citing that the diagnosis was highly questionable. So basically he's saying that, you know, to allow this ruling would be more prejudicial than beneficial. Then he said, actually, I'm sorry, there are 6 of them, not 5 of them. And this is an interesting one. He ruled that the prosecution could let the jury listen to recorded phone calls made by the jailed McMichaels, but he issued a limited gag order on trial lawyers not to comment on inadmissible evidence, including evidence that they reasonably should know to be ruled inadmissible at that. So here you have the McMichaels making statements when they were in jail, and the judge is willing to admit those statements into evidence. Then we have Arbery had some THC on him when he was when his body was found, and the judge did not allow them to bring that up into the courtroom. And last, they excluded evidence that Arbery was on probation when he was murdered.
Okay.
So if now the judge could have ruled differently, the judge could have made other rulings, but these rulings were important. And the reason why they're important is because they show that a trial is not committed in a vacuum, or does not proceed in a vacuum. There are evidence that has to be presented. There are hearings that have to be had beforehand where certain evidence is challenged by either or both sides, and some evidence is deemed creditable and admissible, and some evidence is deemed inadmissible for various reasons. I mean, when most people, non-lawyers, hear about a trial, all they hear about is evidence being objected to there in the courtroom. And there is a lot of potential evidence that never reaches the courtroom. There are only certain objections that are valid once you're in the courtroom. Because if I've objected to a piece of evidence and the judge has ruled that evidence non-admissible in a proceeding, and the other side tries to bring that evidence in, And the judge rules that evidence is so prejudicial that no jury that the defendant cannot get a fair trial because of it, the judge can and should declare a mistrial. Prosecutorial misconduct.
Do you think there was grounds for that?
What?
Do you think there were grounds for that?
There might be. It would be up to the appellate judge. There's certainly a ground in
that. Other than that, yeah, and I watched this testimony, and it I don't know how much you watched or read of it, but it was not going over good. I remember one time the prosecutor asked him, or she asked him, and at any time you could have stopped, correct? And he said, correct. I mean, it was just
obviously he wasn't primed very well.
No, so at this point,
interesting thing, Chris, when we started this, I explained what protection of the castle means.
Mm-hmm.
And that would mean that if somebody is pointing a gun at my wife and I have the wherewithal to pull her away, I don't have to do that. I can shoot.
Yeah, it's kind of like, I'm sorry, go ahead, finish. I'll say what I was going to say.
No, I finished. I can shoot to kill. I don't have to back
well,
up.
no, what I was saying, I don't know if you remember this exactly, but there was a couple years ago in Florida, they had that stand your ground law, and this guy had walked up to this woman and was yelling at her because her husband had parked in a handicap spot. He comes out, and of course he's mad because he's yelling at his wife. He pushes the guy down. He pulls out a gun and shoots him. And at first they tried to rule stand your ground, but then they came back and said, no, push somebody down or 6 feet away, you don't have that right anymore, which I think was obviously the right decision on that.
Yeah.
So, yeah,
that's
I get that's what I said. The only advantage with calling him to stand would have been try to do that. You don't have any advantage at all trying to call the driver or the other guy to the stand, correct? I mean,
as a defense attorney,
yeah.
I mean, I would have no problem if one of the other defendants testified in my case. I wouldn't want my client to testify, no matter who my client was.
Now, something I don't know if we covered earlier. What are the advantages and disadvantages, and who actually made the decision of having all three of these men tried together? Because if I was the other guy who got the lesser sentence, I'm not wanting to be tied to them at all, because I know as the prosecutor, you're trying to tie all three of these men as one, correct?
Absolutely. I have most of the same charges against all of them. One of them, I believe, one of them, the third man, Brian, was not charged with murder for malice. That was probably the most major crime, but he was charged with felony murder because in the process of attempting to stop this guy or to apprehend this guy illegally, this guy was killed. So he became part of the conspiracy or part of the murder team at that point, no matter what but he had no previous bias against this guy that might have wanted him to kill him. Well, the other two probably did, and that's why they were charged with murder with malice along with felony murder. Now, murder with malice is for people listening to this, is probably first-degree intentional murder in most states. Georgia calls it murder with malice, but looking at the statute, that's what it is. So if if other people are listening to this or will listen in the past, they should consider this as the highest form of intentional murder in the state where they're located, or even in the foreign jurisdiction where they're located. Felony murder is different. Felony murder means that if you attempted to commit a felony and somebody was killed during the course of the felony, you can charge the man with murder during the course of the felony, but you're not saying that the initial intent was to murder this person. The initial intent was to cause a felony or to do a felony, and this person was murdered because of it. So that's the difference between murder with malice and felony murder in this case.
Okay. So now the shooter and the father they could have got the death penalty?
They could have, but the prosecution decided not to pro-offer the death penalty. They were not, and that's another thing. In some states, actually in most states, the prosecutor has the right to either seek the death penalty or not. In some states, based upon the actual crime or the facts, the prosecutor has no right not to seek the death penalty, or in some cases, the prosecutor has no right to seek the death penalty. In Georgia, from my research, this is the call of the prosecutor, and the prosecutor herein decided not to seek the death penalty.
Okay. How long? Excuse me. So, was there anybody else that the defense called?
The defense called? I don't think so. I can check that though. The defense called 6 other people who discussed crime in the area and Facebook articles related to crime in the area, but really nothing major, just background testimony.
Yeah, I don't see how that's going to benefit your.
Would you like me to read some of the testimony that?
Yes, by all means, please. Yes.
Yeah. Okay, so he's talking about a criminal increase in the neighborhood, a crime increase in the neighborhood. He's talking about he was aware that items were stolen from that property. No, actually, he was aware that items were stolen from a boat on that property.
Yes.
He knew that several people had entered the property, any one of whom could have stolen items. 12 days before the shooting, he saw Arbery creeping outside the under construction house, and he confronted Arbery, who reached toward his waistband, leading Travis to leave and call 911 because he was not going to chase or investigate someone who might be armed. Very interesting, huh?
I mean, it is, but at the same time, I don't see how this is really going to help in your case, because you drove the man down, boxed him in, shot and killed him. I mean, essentially.
Mm-hmm. Well, that's your whole thing. That's why you never want somebody to testify, because one of the problems is if I put my client, the defendant, on the stand, and he testifies, I've opened him up for cross-examination, and
Right.
and he cannot. And if the prosecutor questions him on anything that he said in direct examination, he cannot claim his Fifth Amendment right, self-incrimination at that point. He's waived it. The only, if he's asked about something entirely different, like if if the prosecutor gets cute, which technically is against the rules, and he says, "Oh, by the way, did you rape so and so 13 years ago at this place?" Then he can obviously use his right against self-incrimination because it has nothing to do with that. I mean, the objection that the defense attorney would make is that it goes outside the scope of the direct examination, and the judge should not allow the question or the answer. But if
So,
the judge did allow it, then in that case he could claim his Fifth Amendment right against self-incrimination. Dan?
I mean, from what you've read me of the testimony or and of the client or the other witness they put on the stand, basically, the defense attorneys, and I'm guessing they had three different ones, they were just hoping I need to get one racist on the jury.
Well, let's be a bit more politically.
I mean, for me,
correct.
and I thought the
They
case
were-
pretty close. There was, I mean, from the evidence, I don't see how they had a chance of getting getting off. I mean, that's the only thing I can think of is you're hoping to get a racist in there that hangs the jury. I mean, but I'm sorry, you're
all right. As I said, let's be a little more politically correct. Someone who believes that the neighborhood is under threat from invaders, and this guy might have been one of them.
okay.
But yeah, that's exactly what I want. I want at least, if I know I'm not going to get an acquittal, and looking at all the evidence and looking at what I've read and looking at the statutes involved, if I'm a decent attorney, I'm pretty sure I'm not going to get an acquittal. I'm going to pray for one jury who will hold out. But the interesting in all that does is give the prosecution another try at me. Because if they
That's
get
true,
11,
but
if they get 11-1 in a case like this, they're going to take another shot at me.
oh yeah.
Now,
I mean, I think in most cases that I've seen, well, in a lot of them they do, but still, I mean, you live to fight another day.
that's true, and also because somebody or maybe two or three people disagreed with the majority, I might be able to get a much better plea bargain.
Well, do you know if I know that after the prosecution arrested that the other guy's attorney tried to get plead him out, and they said no. Which at that point, I mean, why would they? Do you know if they were offered any plea bargains before trial?
No, I don't.
I mean, I couldn't see how the father son would be offered anything. I mean, I might could see where the other guy would get anything.
No, I think they had them all dead to rights. I don't think they were offered any. I don't think a plea bargain was offered.
Yeah, I mean, I don't see how you would. I mean, just yeah, like I said, I think they had them all dead to rights.
Well, don't forget also, you had the whole county refusing to do anything. They've already
right. Yes.
had to bring in another prosecutor. They had to bring in the Georgia Bureau of Investigations, and they had to bring in and they brought in the FBI for some help. So I mean, you've already forced my hand big time. Why would I offer you anything? I mean,
Now,
if there were some more, how should you say, more issues that could be decided in favor of the defendant, then you might offer the least guilty defendant a plea bargain.
which would been the guy who
It would probably be Bryant, the third guy who joined.
now what was he got 30 years of prison, which is essentially going to be a death penalty.
No. He got a lifetime. He got a life sentence, but he has the right for parole in 30 years.
Oh, okay. He got a life sentence, but he will be eligible for parole after 30 years, which is essentially he'd be 82 years old.
The other two got life period.
I'm sorry, what'd you say, Larry?
The other two got life without chance of parole.
Right. But so, so he got life. So is when a judge gives that, says, okay, you got life, but you got to serve a minimum of 30 years. Is there an exact number the judge has to give according to the law, or is that up to the judge?
It all depends on the state. There are some
All depends on the
crimes.
state. Okay. Because I know that the judge said that, I just know the judge said that he showed some type of, he was the only one that showed him remorse out of it, between the three of them.
No. What the judge did is he was not convicted on murder with malice. He was only convicted.
Yeah, but the judge did say that he was the only one that showed any type of remorse over what happened.
Well, and he was also the only one who didn't participate at the beginning. Yeah,
right. Which, I mean, to me, I don't know. Yeah, I'm not a lawyer. Know how it goes. I mean, it looks to me, to me, he's as guilty of the boy's death as the other two. I think the man personally is an idiot. I'm not getting in any type of something like that. If I see somebody chasing somebody,
but he didn't plan. But he didn't sit down and plan something while the other guys were actually convicted of actually knowing this guy and sensing this guy and going after a guy they knew about. This guy claims he never knew Arbery, period, and that he was just helping out. So he didn't have any initial intent. And that's why he wasn't charged with murder with malice. And that's and that may be the only reason why he was given the lesser sentence.
So this is one reason why we should never take the law in our own hands. I mean, if Zeke and Earl had popped another beer and called the police, 4 lives wouldn't be over, and one kid wouldn't be dead, and the other wouldn't be in prison the rest of their lives. Instead, they decided to go jump in the pickup truck and chase them down. Let's just be honest here. This is probably a societal thing. If this had been a white kid, you think they're going to jump in the car and go chase him down with a gun? Me personally, I don't.
Probably not, but I mean, look at.
I'm not trying to bring. I'm just trying to look at it to realize. I think that they saw this black kid, went after him. Now, whether they intentionally, whether they planned to kill him as soon as they left, that's another story. Either way, he ended up dead. But
I mean, the interesting thing is that those pictures from the camera on the property and the owner's and the owner's testimony as presented by the police said that there were white people. There was a white couple who stole 2x4s, and there were other white people who got in and took property. And these guys are only going after a black guy who. And the only thing McMichael knew about him was that, according to the one of the police that testified, was that he was going to be warned to stop trespassing. There was never any statement that Arbery or any black man stole anything from that property. So you're very right. It might very well be a black-white incident or a racial incident.
I mean, I'm just being real with it. I mean, I hate it that that's what some societal things is, but that's what it looked like to me.
I'm a bit.
Chased this black kid down and shot him. I mean,
I'm a bit older than you. I've said I'm a bit older than you, and I can remember the 1960s and the 1970s and the late 1950s, where a white man could kill a black man in many states with impunity.
Well, I can't remember exactly which case it was because I've studied a lot of these civil rights cases, but there was, I think it was Mississippi. It's possible it could have been in Arkansas, but these, they killed this black kid and jury found him guilty or not guilty. And as soon as they trial was over, they both said they killed him. And
Yeah, that's happened many times. But yeah, but that obviously sets them up for a federal prosecution on civil
but at
rights
that time, though,
violation.
you're talking about, I mean, yeah, you probably still could have got it, but in a federal prosecution, you're still going to get, white juries in the South. I mean, because I think, I'm not
Yeah,
mistaken, I think Edgar Ray Killen had some federal juries because the state didn't prosecute him.
right.
I I have I'll say this. I have no sympathy for either three of the men's sentence at all. In this case, just I don't even. I'm gonna. From the time that this happened, I've just been in a total loss of words. I mean, I would just like to say, what the hell were you three thinking?
Well, that's exactly it. But the issue is, I read that ruling, those 6 pre-trial rulings. I would think that at least one of those rulings might very well give a possibility of a judge of an appellate judge overturning the case.
All right. So, is there any other thing that you've seen that might give an overturn for the case?
Only that slight possibility. I think that I think from all I've read on the evidence and everything, the vast majority of what the judge did was proper and above board, and the evidence that was admissible and admitted was generally stuff that should have been admissible and admitted. Actually, if the judge allowed, and the guy tried to use a self-defense argument when he testified, if the judge allowed self-defense as a claim, he was probably bending over backwards to protect the rights of the defendant. Because personally, reading the self-defense statute in Georgia and analyzing it, I don't believe that there could have been a credible claim for self-defense made here. And I just want to refer you to the very first argument that we did. A person is not justified in using force under those circumstances where he initially provokes the use of force against himself with the intent to use such force as an excuse to inflict bodily harm upon the assailant. Now,
well, as somebody, let me just say this right here: somebody who is well versed in the using of firearms, military rifles in general, shotguns, pistols. You don't get close enough to somebody that you have blood on you holding a shotgun unless you were intending to kill them.
Absolutely, and something else that we didn't mention. We mentioned that Gregory, the father, was a former police officer, so he had an acquaintance with guns. The son, was a Coast Guardsman, so as a U.S. military personnel, he would also have an acquaintance with guns.
Yes. He knew about that. I mean, they and then of course one thing that I was and I don't even know if you know the answer to this. Are they going to serve their time in federal or state now?
So far, it looks like they're going to serve it in state. I mean, they've made a motion to have to serve their civil rights violation crimes first in federal and then go back to the state. But Georgia does not have to do that, and I don't think Georgia will at this point.
Um,
There was
that
a
was just
there was a case in New York, and what happened was the person was convicted of two murders. He was convicted of some murder in one of the states with a death penalty. And he was convicted of murder in New York, which does not have a death penalty, but had a 20-year to life statute. Now, the crime in New York was the second crime tried. And from what I gather, there was no agreement of how the cases would be served. So the state with the death penalty wants him back to execute him, and New York said, no, he's going to serve his years here in New York, and then you can have him. And that's the way it was.
So I'm guessing in this trial, there was no time that the prosecution. I mean, well, I'll take that back because like I said, you only got to get one. But I mean, I would have been feeling good the whole time if I was the prosecution. If I was the defense, I'd be like, we're done.
Well, normally, as a prosecutor, as I said previously, I'm prosecuting in a state, I'm prosecuting in a county where I do not reside and where I do not practice in, and I'm using the county's people as the jury. So I don't know, I don't know the neighborhoods that well. I don't know. There's a lot of things I don't know. And it's a much more rural county than I'm from. I'm not 100% sure that I can get a 12-person jury to convict.
Yeah.
I mean, that would be reasonable. The defense attorneys are local. They know the area. They know the people. They're knocking off all the blacks from the jury, and the judge isn't.
They got to be feeling good.
Isn't accepting my challenges that it's racially motivated. I'm extremely worried as a prosecutor and as a defense attorney by knocking off everybody but one black. I'm actually betting on the fact that I can get one racist.
You're feeling pretty good. You can get hung. You can get one.
I can get one, and that would at least, I'm pretty sure. Looking at everything, if I'm an honest defense attorney, I'm pretty sure that I don't see any way in hell that I'm going to get an acquittal. But I can definitely see a decent possibility of a hung jury. And maybe that's why.
I thought that too when going in. I said the jury makeup. I said it's possible they could probably get a hung jury just off that makeup in that county.
Well, I know that's what my wife said when she read it at the time.
And now, I know we touched on this earlier, but did we ever decide did how they ruled to trial them together?
The judge that they made, I think the McMichaels. I don't know if the McMichaels made a motion. I know Bryant made a motion, but the judge thought that they could. There would be no major prejudice to have the three of them tried together.
Of course, Bryant would not want to be, because, like I said, they're going to be trying to tie all three together. Bryant's not want to be tried with them.
I mean, absolutely. I mean, Brian is. By trying the three of them together, Brian is being painted by the same brush.
Right, yeah. That Brian is they've tied. I mean, they're one and the same. Do you think that if Bryant's tried separately, there's a chance of a hung jury?
Yeah.
Let me say this. Let me rephrase it a different way. Do you think there's a better chance of a hung jury?
Yeah. Well, we obviously know what happened. Yeah, if Brian was tried separately, he's not being tried with the most major case that the other people are tried with. So he's being tried with a felony for felony murder. Did he commit a felony? if they can show a proof of kidnapping, he committed a felony. If they only show illegal imprisonment, I'd have to do the research and find out what type of case crime that is in Georgia. I mean, if it's a misdemeanor, and you could only have felony murder, then he could not be. Then if they find him not guilty of kidnapping but only guilty of a misdemeanor, then he can't be found guilty of felony murder.
Ah, so how did your strategy there change as a defense attorney? Are you still just like attacking this? How are you attacking the states that, hey, he just seen these guys chasing him. He's trying to protect the neighborhood. He didn't know what was going on.
Yeah, it's exactly what I'm doing, and I'm saying
you're trying to portray him in a sympathetic light. He's the other victim in this. Is that a fair statement?
Well, that's what I'd try to make him if I was the defense attorney. I'd want him to be the victim.
Yeah, okay. He's the other victim. He's the other victim in the case. Make him into a sympathetic figure. He got caught in this by these evil two who was just trying to be a good citizen.
And you know what the interesting thing is? And I would have put people on if I could have, and I don't know if I could have not, I would have tried to get witnesses testifying on my behalf of my caring nature and how I'm worried about the crime in the neighborhood and all that type of stuff. Character witnesses, exactly.
Okay. That's a whole different ballgame in that case. I mean, as far as like how a jury would look at it, I mean, it would have been better. He would have been a lot better off.
Oh, absolutely. And I'm sure that's one of the grounds for his appeal, that it was more prejudicial.
Well, I did hear his defense attorney say confidently he thought that he would get that overturned on appeal because of that.
Yeah.
But whether that's the case or not,
prejudicial to try me with these two guys than to try me separately.
All right, it's been very interesting. When we cut, I'll ask you about the next case. That's really all the questions I had, all the answers. I mean, I think you did a fantastic job analyzing that by what the law says and what you got to go with, and defense and jurors. I really enjoyed that.
Well, thank you. One of my best attributes as an attorney is I was able to read and interpret laws and statutes and contracts. So I mean, this is So I mean, and not all attorneys can. I mean, I remember one time we were doing elections, and I was an absentee ballot moderator, and the overall moderator looked at the counting on one of the constables and said, "We're going to need to have a recount." And he read the law, and everybody's agreeing. And I said, "That doesn't say that. The law you just read allows us not to have a recount on this matter." And I read it point and verse, and I pointed it out to him. And then everybody agreed with me.
As far, I mean, you break it down great. I mean, this is going to be a fun thing. I think everybody's going to enjoy that. Maybe cut it into several videos, but I mean, the way you break it down is excellent, Larry.
Thank you.
All right, we'll talk soon.
Yep. Be well.
All right, Larry. That was. I'm gonna listen to that again. I thought that was very well.
Thanks. Yeah, I enjoyed it. I mean, you know, when I first looked at it, what really got me interested in the whole thing was the claim